Gentlemen, I take it there are ladies and gentlemen. Good afternoon. I hope I'm talking to my future colleagues at the Supreme Court. All of you are already lawyers. Learned your law at colleges across the country. I hope I am right in so believing. I further believe I'm not teaching law to you. You are already lawyers. Let me introduce myself. I have not been an AOR. I have not been an advocate on record at any time during my practice at the Supreme Court over 50 years from 1964. I have enjoyed the association of several advocates on record in preparing and presenting cases before court. Those whom I am able to see on this online performance, you must be very intelligent in appearance. I believe so. There is no bar for you to address the court without being an AOR. During this period of training, you must have appeared before the Supreme Court occasionally, and you have no shortcoming in this behalf. That means your practice as lawyer is not affected, your appearance is not affected, but you need an associate like AOR. It is what I have understood over the years by AOR is it is a mix-up. You are a solicitor, you have copied the functions of a solicitor abroad, and you have made it our special feature. You can also appear in court, whereas a solicitor does not appear and talk to the court. That's an experiment made that has lasted all these years. So initially they were called agents, later on advocates on record. And when the examination system has been introduced, it has become established practice under the rules of the Supreme Court that you can prepare, appear, talk to the court, and also appear with a senior or a non-advocate on record. And with your association, you can together prepare and present the case through your senior or any non-advocate on record. That's how the system has worked. Initially, it appeared a little funny to me, but over the years, we have all got used to that system. Why should such a mix-up of a citizen procedure continue is another matter. I thought at best it had the merit of having your address within the Delhi region so that if Supreme Court wants to serve any notices, they could do so. But here you have additional aspects like how do you practice, what is ethics about it, what is accounts keeping, and how do you prepare decided cases, what is their use. All this is brought in, and an examination is. You have already passed all examinations. I take it that you have read Supreme Court decisions many times at the level of being students while learning law, while taking examination as LLB student or otherwise. Now, if you come to this list of 64 cases described as leading cases, they are made available to all of you. as leading cases, you will notice that they are all Supreme Court decided cases. There is nothing like knowing anything decided by high courts, even if it is more important and more effective. That's another aspect of this list of 64 leading cases. Now, I am grateful to my predecessor, senior advocate, Sri Maralapalle, a former judge from Bombay High Court. He has been good enough to explain these cases involving different laws to all of you, possibly yesterday or day before yesterday. Indeed, it's good of him, and I thank him profusely. I bet you were taught these and more cases while doing your law courses. Of course, a feature of these 64 cases is that they are cases decided by Supreme Court. There could be important cases decided by high courts also. That part is not taken into account in this examination because you are all wanting to practice in the Supreme Court. Very interesting is there are many who made that decision to practice in Supreme Court. They don't take exam only if you want to assist or develop as a counsel talking, and as well as filing, you are made to take examination. That is another matter. I don't go into it. You are slated to take exams time to time, even after completing law course. See, I would like to ask you, do you find, after seeing these 64 cases and after hearing my eminent predecessor, senior advocate, Mr. Maralapalle, who had been a judge earlier, do you think you have found anything as a special way of writing judgments or deciding cases by Supreme Court judges? After all, most of them are former High Court judges. Even Supreme Court judges, mostly 90% and above, are former High Court judges. They have experienced over the years and they write judgments. In fact, very small number of directly appointed judges, for having recognized their merit in a manner slightly different from the elevation of High Court judges, they would not have experience of writing judgments. Now, many times I have said, if I can repeat, not so much seriously, but for you to appreciate, in Supreme Court, senior advocates do not draft anything. They present the case, they argue, instructed by advocates on record. Now, advocates on record draft, or their assistants or their juniors in their office, they draft, but it goes in the name of the advocate on record. Now, advocate on record drafts. The only section of the bar in Supreme Court which drafts anything is the section of advocates on record. Now, you are all preparing to write judgments if elevated to the Supreme Court. Those elevated to Supreme Court are all former senior advocates. Now, senior advocates would not have had experience in drafting judgments. So they will have to look up to the others, mostly from former judges of the high courts who have got elevated, to learn how to prepare judgments after elevation. Now, these 64 cases, you will find across mostly 95% to 99% are written by such judges, high court judges, who have been elevated as judges of the Supreme Court. Very few judgments are prepared by directly appointed judges, if I have glanced through this list. That is another aspect to think over. Now, which part of these 64 judgments have impressed you? I can't get your views across for my benefit. I take it that all of you want to know about these cases and know more. Otherwise, it should inspire you to study not only these 64 cases, but several other cases. Now, writing part is an aspect, very important. See, for example, when I joined the bar, our seniors guided us saying that you must read the volumes of Indian appeals prepared by the Privy Council at London on appeals from India. So they are all small bound books, small. But not only binding is small, but writing is also small. With the result, when you read Privy Council judgments, you really develop an appreciation for judgment writing. Now, if I tell you that in the beginning, read Supreme Court judges, from where to where? I ask myself, all right, from 1950 to 2020. Now, if you read these volumes for the similar period of time, these volumes amount to, say, at least 50 times more reading material of judgments over the period. Maybe you may attribute it that you have made it easy for people of India not only to think of Supreme Court as a constitutional court, but as a court of appeal, an appeal court above the high courts. That makes it the third court or the fourth court occasionally. So in that manner, Supreme Court has been both a constitutional court and an appellate court over the judgments of the high courts. So many times, high court judges elevated to Supreme Court will be sitting in appeal over the judgments rendered by their erstwhile colleagues. And so it has brought into account certain thinking process on the part of judges in a manner, I must grant leave, or no, it is very satisfactory. He's a very hardworking judge. I don't think Supreme Court should be troubled to interfere. Either way, it can happen. So that way, now, I would not go into several laws under which these 64 cases have been decided. I for one, take out those where the Supreme Court has decided constitutional questions, where it has developed law concerning fundamental rights, or in approaching Supreme Court itself for violation of fundamental rights, like Article 32. Let me give you some experiences at Supreme Court in the initial years. My senior once asked me to get a white paper from the library. I was very new in my third year. Having practiced in Bangalore for 3 years, it was first 6 months in the Supreme Court. So I didn't know what he was meaning as a white paper. So I went in, took a typing paper, white paper, and gave him. He had a hearty laugh, and it was a typing paper. My senior laughed and remarked, as silly of me. He explained that there was a book published by the government of India as a white paper containing matters concerning erstwhile princely states executing agreements of merger into India, Indian Union. So this small experience taught me how to be careful in knowing law books on that itself. How many know what are law books? And spread over several rooms in the Bar Association or in the Judges Library, where also you are likely to get access. That also has to be taught. Now, thereafter, we come to the question of how to write judgments and what is the message. What is special about cases decided by Supreme Court? I want to ask you. We will discuss a few of them. What is their value? Can any of you tell me instantly, or of course, I shall tell you. Why is this lecture organized to talk about the judgments prepared by Supreme Court? What is so special about it that a practitioner ought to know these cases decided by Supreme? All of them are not on matters constitutional. Some of them are. Then in all other languages, in all other laws also, there are cases. Now, why have they collected all of them? For your benefit and asking you to listen to this lecture. Why should I give a lecture to you, a law student, who has already known how many cases? Hello, can you, sir? Can I continue? Hello?
Yes, sir. Yes, sir.
Can you hear me?
Yes, sir.
Sorry for the disturbance. Now, I ask you, what is so special about the pronouncements of the Supreme Court? Are you knowing that, my dear advocates? Are you knowing that? Why is this special? Supreme Court pronouncement. Can you tell me what are the special features of Supreme Court judgment? If you are not allowed to convey through this online procedure, I will proceed and tell you what is that special feature. The special feature is in Article 141 of the Constitution. Article 141 says the pronouncements of the Supreme Court are law for the country. They are binding on all courts in India. So that is the significance of decisions made by the Supreme Court. If it is law for the whole country, then it is very important. It is good to know law as a subject to learn, and it is good to know judge-made laws. This is additional. Judge-pronounced decisions are also law for the whole country. So you must be equipped with law which you have acquired in doing law course at universities. And additionally, you must know the decisions made, the leading cases of the Supreme Court, so that the two together equip you with what is law for the country. Now, I would have asked you more in details, but we are not having that chance. Now, I must tell you, you are all special persons going to practice in Supreme Court. Supreme Court has the requirement that you should have your address within the NCR or within certain area in Delhi so that you are accessible for service of notices, etc. It's a very small procedural requirement, but that's it. Now, but you have additional advantage. Once you settle down in Delhi, in the name of practice at Supreme Court, whether you gather work or not, you will take some time. You will take some time. But in the process, you have advantages of practice, not only in Supreme Court, but other. अब कहाँ कर दिया? Sorry for this. Now I will tell you, please note, my friends, you are all going to be advocates on record. You want to be. Now, what are the advantages of settling down in Delhi? Apart from Supreme Court, you take it as big Roman one. There are tribunals headed by former Supreme Court judges. Sorry, my apologies for interruption. The advantages of settling down in Delhi are these. Supreme Court, your base. It is your base. You need time to develop your law practice there. In the meanwhile, what do? I request you to take interest in several tribunals located in Delhi. It is rare that there is combination. They are all headed by either former Supreme Court judges or former High Court judges, like service tribunals, consumer tribunals, customs tribunal, income tax tribunal, ITO, and above all, the High Court of Delhi itself. So all these are amenable to law practice in addition to Supreme Court. This kind of where more opportunities are not available in any state capital. So thank you so much, sir. Thank you so much. फिर आता है कौन विक्की? तुम्हारे फोन है ना इसके में सोचो जरा मैंने तो मना किया ये रख. Sorry, sir. I will continue. Can I continue?
Yes, sir. Yes, sir.
Yeah. Now, all these benefits are there for you, my friends, would-be advocates on record. You will all be colleagues to me here. Now, you have had enough lecture on 64 cases from my eminent predecessor, Mr. Marlapalle. I will only take about 4 or 5 cases so that you understand what I have been all the while trying to convey to you. Now, I'll take Maneka Gandhi case. I hope you have already not been informed about it, but I will make it a short work. Now, Maneka Gandhi's passport was confiscated without providing her the reasons for the same. This was in 1977-78. But there was a statement in the order of confiscation that it was issued in the interest of general public. She approached the Supreme Court by filing a writ petition under Article 32, saying that her fundamental rights under Articles 14, that is right to equality, Article 19, right to property, and 21 to free expression and others. Now, the questions for the court to answer were these. What is the scope of fundamental rights? Whether they are conditional or they are absolute. And then, what is the right to travel abroad? Is it covered under the ambit of Article 21? Now, Article 21, you know that it is right to free speech and expression. Free speech and expression. Now, can that be extended and say that it takes in your right to travel abroad or not? That's the question. Then are Articles 14, 19, and 21 mutually exclusive, or are they dependent on each other? And scope of procedure established by law. You see, what was being looked at? Was it confiscated according to procedure established by law? There is a section in the Passport Act, section 10(3)(c), under which her passport was seized. Is it violative of fundamental rights? It has been seized under the powers vested by the Passport Act, section 10(3)(c). But is it violative of her fundamental rights? That was the question. And they proceeded to consider that for and against. The government, of course, said that it was all within their powers. She had no right to question that. Now, if it is only the case of seizure of the passport, we are willing to give it back to her. But the question is it violative of articles of the fundamental rights? So then, what did this court say? Why, though Maneka Gandhi's worry was overcome by return of the passport, the court was asked to continue and decide it. And indeed, today the court does not yield to such requests, but in those days, 1978, 77, 78, it was court accepted to consider whether there was any violation of fundamental rights. So it said the confiscation is violative of Articles 14 and 21. 14 is right to equality, and 21, free expression and free speech. It was extended by the apex court in the case of Satwant Singh, Sonam, and Ramaratnam, that the term personal ambit includes under its ambit the right to move freely and travel abroad too, and no person can be deprived of such rights except through procedures established by law. And since there exists no law prohibiting the same, therefore the confiscation is void and legal. This is what is said by the Supreme Court by reference to the previous pronouncement, Satwant Singh. Now, the central government did not disclose the reason for confiscation of the passport, and it was stated explicit that the confiscation wasn't necessarily done for the interest of general public. So they expressed that the confiscation was not in the interest of general public. Then they proceed to say the fundamental rights conferred in Part 3 of the Constitution are not distinctive or mutually exclusive, and overruled the A.K. Gopalan concept that there exists a link between Articles 14, 19, and 21, whereas Gopalan case had held that they were mutually exclusive. Therefore, it was said that fundamental rights are not distinctive. The concerned section here, that is section 10(3)(c) of the Passport Act, is not violative of any fundamental right. The right to go abroad does not form part of Article 21 either, of right to free speech and expression. Both of them have different nature and characters. In other words, in a short way, they went into the matter, and the honorable judges pronounced that there could be violation, but on the whole, Article 21 does not take in the right to go abroad. And if that there was any violation of fundamental right, does not form part of Article 21. Therefore, but on the facts of this case, it had already been concluded by central government returning the passport. So this is more in the nature of obiter, and not necessary to decide that particular case. But on a request from both sides, they did go into the matter, and they did decide in this manner. You are aware of it. It is one of the oft-cited cases decided by the Supreme Court. Now, next case is, I take Chandar Kumar versus Union of India. This relates to the competence of the tribunals set up. Tribunals, you see, in order to expedite disposal of mounting arrears, maybe in different ways, the load was reduced not only for Supreme Court, but also for the High Courts. They set up, by virtue of the constitutional amendment, under Articles 323A and 323B, whether the exclusion of High Court's jurisdiction. Otherwise, under Article 226, a High Court had extensive jurisdiction. It is nothing short of, on all aspects, the High Court could decide and do justice according to constitutional requirement. But having done this, a new chapter was started with the establishment of tribunals headed by former judges or the present judges to decide cases by way of judicial review. And is this now, what questions arise in your minds as well as a reader of the judgments deciding constitutional questions are these. Now, is it correct that the doctrine of judicial review forms part of basic structure of the Constitution? If that is so, that had been vested in the high courts also. High courts were created by the Constitution itself. So if a high court set up by the constitutional power had been invested in this power of judicial review, that was in order. Now, if it is to be divested and it is to be left to the judicial tribunals. Now, please consider, these tribunals are also, if you treat them as creatures of the constitutional power, then the tribunals also can so take in their jurisdiction and decide cases. Now, in the Sampath Kumar judgment, previously, the Supreme Court in its final decision had held that even though judicial review constitutes the basic structure of the Constitution, still vesting of the same in an alternative institutional mechanism, that's the tribunals, and taking it away from the High Court would not be violative of the Constitution if it is maintained and ensured that the alternative institutional mechanism is an effective and real of the effective solution, alternative to the high courts. Subsequently, the court factored in various other rulings, even minority opinions of honorable judges, and also opinions of learned counsel to arrive at a conclusion. Some of them can be summed up as follows. Now, they went in depth. This was an important question because the constitutional powers were being divested from the high courts and invested in the tribunals so created. And then, for example, the Administrative Tribunals Act, it held that judicial review was indeed a part of basic structure of the Constitution. This was the rationale of the judgment of the rulings of the court can be described. Now, it held that judicial review was indeed a part of the basic structure of the Constitution. And so, it could be conferred on tribunals also. It agreed that the Sampath Kumar case was correct in supporting the theory of alternative institutional mechanism in backdrop of backlog of cases in the high courts. However, it reiterated that the high courts and Supreme Court's jurisdiction should be retained and the tribunals will be performing supplementary role and not the substitution role. It is not substituting, but it is supplementing. It's how the court coined its wordings for the decision. And moreover, the tribunals will be granted with supplementary power of judicial review. So it is in this manner that the High Court described the tribunals so set up. The court held that the tribunal will possess the powers of testing the constitutional validity of statutory provisions, with the same being subject to review by the High Court. That's the decision of the tribunal would be carried to the High Court in appeal. So it is not that the High Court was ever divested of its power. The court rejected the prayer that appointment of administrative members to the administrative tribunals should be stopped, as it felt that the balanced mixture of judicial members and non-judicial members will make the affairs much more effective. This is how the reasoning went and saved the constitutional power to test the constitutional effectiveness of fundamental rights and the violations contemplated in the High Court and its extensive power. And that's how they rendered that decision. Now, in the next one, I will take is the next one I will take is Vellore Citizens Welfare Forum versus Union of India. This is 1996, Volume 5, SCC 647, a bench headed by Justice Kuldeep Singh. Now, issue involved here was, see, tanneries and other industries had the inherent aspect of creating pollution in that area. And the question that arose before the High Court was whether these tanneries should be allowed to keep working at the expense of the health and of individuals and of the environment. Now, this is comparable to present Delhi's problem, like building constructions and other activities, including industrial activities. When Delhi is overtaken by smog, this is a current topic which is going on. Many orders are issued for the builders to stop, orders are issued for industries to stop during this period and until it is overcome. The petitioners in Vellore Citizens Welfare Forum, they approached the Supreme Court under exercising their fundamental right to approach the Supreme Court under Article 32 against the water pollution caused by the tanneries and other industries by releasing excessive pollutants in the river Palar in Tamil Nadu, thereby hindering the main source of water for the livelihood of the local population. It was also affirmed by the Tamil Nadu Agricultural University Research Center that the pollution was rendered thousands of hectares of agricultural land barren and not fit for cultivation. Next was the learned counsel for the petitioners demonstrated a study conducted by the non-administrative association that uncovered that 350 wells out of 467 wells in the 13 towns of Dindigul and Pediyar, Chatram and unions are so contaminated so as not fit for drinking purposes. These were the arguments taken into account. Counsel for the respondent held forth that the quality concerning local dissolved solids fixed by the board wasn't legitimized, and the Ministry of Environment and Forests has not completely set down models for inland surface. Now, the Supreme Court went into these matters, these special features of the area, and rendered their views that the tanneries are posing health hazards to the locals nearby and is immensely harming the environment too. That's how the Supreme Court came to think. The court also held that the same tanneries are a major foreign exchange earners to the country and are providing employment to several people too. So the court got involved in two opposite viewpoints and the outcome of the two activities. At the end, the court opined in favor of the petitioners and ordered all the tanneries not to stop, but to deposit a fine of rupees 10,000 in the office of collector. And the court also directed the state of Tamil Nadu to award Mr. M.C. Mehta, who had rendered great service, with a sum of rupees 50,000 rupees as a token of appreciation for his contribution towards protecting environment. Moreover, court also emphasized for the formation of green tribunal benches in dealing with matters related to protection of environment. Protection of environment was left over to the in-depth study by the Green Tribunal's benches. One was located in Madras. So this is how they dealt with these questions, having constitutional import and entertaining an Article 32 petition. This is how it was done. Now, I take one more case, that is K.S. Puttaswamy versus Union of India. You may have already done or you may not have done. I have no means to know, but I will deal with this in the sense that Aadhaar card, when it was brought in, question arose. One of the important aspects was whether it was merely an unique identification of families or personalities or below poverty lines families. The petitioners alleged, one of the petitioners, it was led by a former judge of the Karnataka High Court. They alleged the Aadhaar being violative of right to privacy, which according to them formed part of the fundamental rights under Article 21. You see, if you have seen an Aadhaar card containing so many particulars of the person concerned, apart from his photograph. Now, is it to be displayed in several places in activities of daily import, whether all this will affect the right to privacy? Is it violative right to privacy? After the passage of the Aadhaar Act in 2016, they filed another PIL, which subsequently was merged in the previous. Now, the court had to take into account several grounds. One of them was whether it would create a surveillance state. Is Aadhaar, the next is Aadhaar violating the right to privacy of citizens? Then is it a money bill? Can Aadhaar Act be considered as a money bill as it was passed as one under Article 110 as a money bill? On all these grounds, could it be rendered ineffective? Now, what has happened is Article 139 AA of the Income Tax Act was violative of the right to privacy. Now, there are other provisions. Will they be rendered right to privacy? Then Rule 9A of the Prevention of Money Laundering Maintenance of Records Rules 2005, which mandated the linking of Aadhaar with bank accounts, are valid. Now, if Aadhaar and bank accounts are combined, is it in order, or is it within the clutches of the Prevention of Money Laundering, Maintenance of Records rules, 2005, whether a Department of Telecommunications circular which mandated the linking of mobile number with Aadhaar, is it valid? Such questions were entertained and gone in depth. The court could not have avoided. Court had to take into account all these aspects into account. Where, apart from, of course, world over, there are several cards of this kind. Even inside India, there are cards which do disclose particulars of the person concerned. Cards, the banking card, PAN card, and the similar cases. Now, the decision is, what did the Supreme Court pronounce? It's important to note that in its previous judgment of 2017, the court had held privacy to be an integral component of Part 3, fundamental rights prescribed in Part 3 of the Constitution. But the right to privacy isn't an absolute right, and any invasion of privacy by state or non-state actors must satisfy a triple test. That includes 1, legitimate aim; 2, proportionality; 3, legality. And lastly, court struck down 2 previously landmark judgments, which are MP Sharma and Khadak Singh, which opined that the right to privacy is not protected by the Constitution. In the current judgment, a 5-judge bench led by Chief Justice Deepak Mishra held Aadhaar Act to be valid. The apex court made it mandatory for availing the benefits and subsidies of the government. Though children won't be denied any benefits if they don't possess the Aadhaar. However, no, the court held that Section 57 of the Act as unconstitutional and struck down in a part. It asked the government to provide more security in order to protect data of the people. It held that the data collected by Aadhaar should not be shared with commercial banks, payment banks, and e-wallet companies. So this much protection the Supreme Court extended, but upheld the validity of the Aadhaar card. Telecom companies can't ask Aadhaar details while issuing a SIM card. The national security exception was struck down. The court held that the linking of Aadhaar with PAN is not needed, as there isn't any constitutional rationale behind it. So they have considered in details only where there is all angles clear that they have proceeded to strike it down. Otherwise, they have upheld their Aadhaar card as it is prescribed. Now, I hope I have made myself clear in explaining to you. Now, there's one more case that I would like to take up is Rupa Ashok Pura versus Ashok Pura. You see, it involves case of almost questioning the correctness of the judgment pronounced by the Supreme Court under Article 32. Now, there is a provision for review. Even then, can you still question the power of review also in a manner whether a writ petition under Article 32 of the Indian Constitution can be maintained to question the validity of a judgment of this court after a petition of review of the said judgment has been dismissed. So this posed a very direct threat in a way. How can you see if Supreme Court is the last stage? It has rendered its judgment by itself. By rendering its judgment by itself, it is final. There is nothing further. But there is a review. That review is also dismissed. Then why anything more? So they gave rise to something called a curative. in that manner, it is like seeking a writ of certiorari against the judgment of a superior court, a Supreme Court itself. So all the learned counsel considered that the jurisdiction of the court under Article 32 cannot be invoked to challenge the validity of the judgment of the court after exhausting the available remedy under Article 137 and under the Supreme Court rules. Although there was a unanimous prayer for them that there should be a lifeline left with the aggrieved after he exhausts the review petition in order to avoid miscarriage of justice. So they wanted it that way. They had approached the Supreme Court to say, invent something. But totally putting a full stop is denial of miscarriage of justice, if it is possible to explain and make it a foolproof case of miscarriage of justice. Now, in this case, for example, Antule's case was cited. Venugopal cited the United States of America versus Ohio Power Company. Now, there must always be that power left in the court. Court also expressed there should be in existence of very strong reasons, and it should be in the rarest of rare cases that such curative petitions are entertained. So they only used words of making it rare, and rarest of rare case means it is the viewpoint of a judge hearing. And the curative petition should contain a certificate by a senior advocate. Now, that has been an effective impediment for giving rise to large number of curative petitions. The senior advocates must act with a sense of responsibility. Senior advocates are amenable to Advocates Act and discipline, and therefore it has been an effective solution for controlling the onslaught of several review petitions. Coming to the nitty-gritty of these curative petitions, the Supreme Court shall have inherent and plenary jurisdiction to hear such petitions. And it is the Supreme Court rules which state that dismissal of a review petition under 137, under Article 137 of the Constitution, a curative petition can be filed under the inherent jurisdiction of the apex court in order to prevent gross miscarriage of justice. So what is the significance of this judgment is they uphold considerations of justice, that there should be no feeling left of miscarriage of justice in anyone approaching the Supreme Court. Therefore, this stands apart as a benchmark in the field of judicial scrutiny and reaffirms the belief that law should be flexible and not rigid so that its fruit can be benefited by the aggrieved. This is it is an innovation made by Supreme Court itself in prescribing frontiers of jurisdiction under its inherent power. I have taken a lot of your time. I hope I have explained. All these cases are very important. I have taken a few where constitutional aspects have carried weight with the Supreme Court. That should be so. That should be so. In fact, I feel strongly, speaking, you are newcomers into the Supreme Court practice. You will have a chance to reflect upon whether you have done right or you have done something questionable. You see, this was conceived as an institution of constitution, important constitutional court. Therefore, the court started with 7 judges, something like the American pattern to be followed. 7 judges. Then they became 9 judges. And they felt that they could also give kind of guidance to the high courts and entertain few matters like the Privy Council. That is why, whereas high courts had been invested with the power to grant leave of appeal, leave means appeal to Supreme Court under Article 133 and 134. So a Supreme Court was invested with the power to grant special leave. Even if the High Court did not, the Supreme Court can entertain an appeal, and that power was under Article 136. It is all dependent on their lordships, in which direction they must carry this court. Now, if they feel that so many cases have been wrongly decided by the high courts, if the high court judges have not been worthy of their office in such a large number of cases that every day it has started, I have seen this court listing 4 to 5 matters in a courtroom, even if the courtrooms were only 4. Today, with 13 or 15 courtrooms, each court having 50 matters for deciding whether an appeal should be admitted in this court or not. In simple language, what is special leave, what is leave? It is whether the matter should be admitted for further consideration or not. So if you have enlarged the scope of your own jurisdiction, appellate jurisdiction, that you are content, you are very satisfied that you have set the course of justice in order, that even if it is the 4th court, even if it is in some matters 3rd court, but it is never less than 3 courts. And Article 32 is not so much in use. That's what so Supreme Court Constitution Bench is not in daily session, as we used to see in the early days during Gajendra Kar's time and thereafter for about 4 or 7 cases, 4 or 5 years, that Supreme Court Constitution Bench was always in session. It is no longer so. They are all struggling in combinations of 2s or 3s in converting this court into an appellate court. This is a matter for you to guide, because if you are converting it into an appellate court, more the merrier. Advocates will flock here. Your number is today 1100, I was told, listening to this homily. Now, 1100 more than what it was. The whole of the Supreme Court bar was 350 when I came here. There were so many in the list, but never appearing. So altogether, even that list would not be between 500 to 600. Today, we are in the region of 10,000s. And you will be adding to those 10,000s. Yes, if Supreme Court is a final appellate court, so be it. Wish you all good luck. Wish you a good future. This is not like a training. Of course, this examination cannot be compared with the Bar Council examination of yesteryears. This is a special effort by the bar to control the newcomers. Wish this system also all well. May I conclude by thanking you. Thank you for your patience. I have not had the chance to look at you or to exchange questions.
Thank you,
Thank you
sir.
so much, sir.
Thank you very much, sir.
Thank you.